First, look, thank you very much, everyone, for joining us for this wonderful Jus Mundi Academic Network event in what we call the Agora series, which is a series of public discussions open to the public in relation to pressing topics in international law and international arbitration, indeed arbitration in general. We are very privileged to have some amazing guests today. And I'll introduce them to you in a moment. But I wanted to first give you a bit of an overview of the topic, which no doubt many of you would have seen when you registered for this event. So really the event topic today is the Code of Conduct of Arbitrators in ISDS. So in particular, multiple hatting, cooling off, and party autonomy. Now, why are we addressing this topic? Working Group 3 of UNCITRAL has recently reached agreement on a code of conduct for arbitrators in ISDS. And so this seminar really explores how the code of conduct was agreed and what the leading provisions are, and it explores some dynamics and tensions in the outcomes related to multiple hatting, cooling off, and party autonomy. And as I was discussing with our speakers just before we went live, really this is a niche topic, but it is quite a meaningful topic in the cause of multilateral responses to international investment arbitration. We will firstly have an overview from our guests from UNCITRAL, and I will introduce them in a minute, and then we'll dive down into those deep issues. So firstly, I want to introduce our speakers, and then I'll say a little bit about Jus Mundi itself and what Jus Mundi is. So firstly, as our first speaker, we have Corentin Baslé, an Associate Legal Officer at the International Trade Law Division of the United Nations Office of Legal Affairs. So he also serves as the Secretariat, of UNCITRAL in Vienna in Austria. And his functions include servicing the session of the UNCITRAL Working Group 3 of the Reform of Investor-State Dispute Settlement, Working Group 4 on Electronic Commerce, as well as carrying out related legislative work and undertaking the capacity building activities. Prior to joining UNCITRAL, Corentin was a qualified lawyer in Paris and London, where he was involved in a number of international arbitration and interstate disputes. So thank you, Corentin, for joining us. Also from the United Nations Office of Legal Affairs, from the ITLD, is Jae-Sung Lee. So he's a senior legal officer at the ITLD, and this group functions as the substantive secretariat for UNCITRAL. So he currently functions as the secretary of Working Group 3 on Investor-State Dispute Settlement Reform, and has functioned as secretariats of the working groups on dispute resolution, electronic commerce, and secured transactions. Before joining the United Nations in 2007, Jae-Sung served in the Korean Ministry of Foreign Affairs. A Korean national, Jae-Sung is a graduate of Seoul National University College of Law, holds LLM degrees from Seoul National University Graduate School of International Studies and NYU School of Law, as well as a PhD in law from the Seoul National University. We then have Professor Loukas Mistelis, whom many in the audience would know through his work as the Clyde Professor of Transnational Commercial Law and Arbitration at the Centre for Commercial Law Studies, Queen Mary University of London. He is also an international arbitration partner with Clyde & Co. LLP. So Loukas is an acknowledged authority on international dispute resolution and has extensive experience in international commercial and investment arbitration and international commercial law and public international law. He is listed since 2007 on the Who's Who Commercial Arbitration, and since 2017 as Global Thought Leaders in International Arbitration. He has been listed in the Legal 500 International Arbitration Power List since its inaugural year in 2019. And his substantial arbitration experience covers, of course, ad hoc, ICC, ICSID, LCIA, UNCITRAL, GCC, FCC, Swiss Chambers, and Moscow cases, also emergency arbitrator proceedings under ICC rules. And last but certainly not least, Dr. Carina Boltag is an associate professor in international arbitration at Stockholm University and qualified attorney at law with over 20 years of extensive practice experience in various aspects of international dispute resolution, private and public international law. Corentin is the academic director of the LLM in International Commercial Arbitration Law at Stockholm University and a member of the board of the SCC Arbitration Institute. Corentin is also the managing editor of the Clua Arbitration blog, co-managing editor of the ITA Arbitration Report, and a member of editorial boards of many prestigious journals and book series in the field, including the Journal of International Arbitration. She publishes extensively on commercial and investment arbitration topics, and many of you will be familiar with her work. She is also a member of the IBA task force on the revision of the important 2014 IBA guidelines on conflicts of interest, which of course feed into this other work with UNCITRAL. And since 2018, Corentin is a delegate observer to the United Nations Commission on International Trade Law, so UNCITRAL, and she's currently participating in Working Group 2 and Working Group 3 in that process. Of course, very like Loukas, she has been appointed as arbitrator in numerous arbitrations under the rules of ICC, LCIA, SIAC, SCC, FAI, VIAC, and others. And she has acted as expert and counsel in various international commercial and investment arbitrations. So you can imagine how much of a privilege it is for Jus Mundi to have these amazing world experts in international arbitration joining us today. And just looking at the time, I want to really just give a little overview of what Jus Mundi is and what it does. So Jus Mundi is a global research engine on international law and arbitration. We have a public-facing search engine, which allows the public, the general public, to search, do basic searches in international arbitration materials, which we host for free on the open internet. And we also have more granular research functions that many law firms around the world subscribe to, governments, the top universities in the world that specialize in international law and arbitration also subscribe to Jus Mundi for that more granular search capability. And they do that because we believe in not only providing these materials to people who need them and subscribe, but also we believe that building the global rule of law is everybody's responsibility, including providing most of these materials for free, available to the public. So without further discussion on that topic, we are privileged to start this seminar. And I want to really open with Corentin, who is really going to set the scene for us about a broad overview of the UNCITRAL Code of Conduct for Arbitrators in international investment dispute resolution. So I hand over to Corentin, who will share his screen.
Thank you, Andrew. Good morning, good afternoon, and good evening indeed to everyone. Thank you to Jus Mundi for the kind invitation to present you today the Code of Conduct for Arbitrators. I'm here with my colleague Jus Mundi, and we are very happy to provide you with a bit of a background and history on this code, and also delve into some of the main issues on conflicts of interest that are addressed in this code. So I will start sharing my screen now. And I will start by providing you with a bit of background on the work done so far on the Code of Conduct for Arbitrators and on the process itself at UNCITRAL Working Group 3. So as you know, the draft code for arbitrators, along with the draft code for judges in international investment dispute resolution, will be presented to the Commission this year for adoption. After a process that started back in 2017, when the working group first considered the topics on the investor-state dispute settlement reform and started thinking of ways to improve certain procedural aspects of the ISDS regime, also bearing in mind that the working group has been entrusted at that time with a mandate to conduct procedural reform of ISDS rather than reforming substantive aspects of the law of international investments. So during the first sessions of the working group identified a number of issues and concerns with regard to the ISDS regime, and in particular on aspects that were deemed to affect the legitimacy of ISDS, also including in the eyes of the public. And among these concerns, the question of independence and impartiality of arbitrators arose, along with the question of transparency, repeat appointments, double hatting, and also the possible existence of conflicts of interest. So the working group therefore identified a code of conduct or a code of ethics for arbitrators as a possible reform element, which would contain obligations on ethical duties for arbitrators, and decided that this code could also apply to potential members of a standing mechanism in ISDS, which is another reform element that the working group is currently looking at. So as a result, the first versions of the code only refer to adjudicators to encompass both arbitrators and judges of such mechanism, but we will see now that we do have two separate texts for arbitrators and judges. So the working group then requested the UNCITRAL Secretariat to prepare drafts of the code after considering and conducting a comparative review of the existing standards in other international instruments, such as arbitration rules, investment treaties, or codes of conduct of international courts and tribunals. And in preparing these drafts, the UNCITRAL Secretariat was not alone, as you can see, since the Exit Secretariat had expressed its willingness to also contribute to the drafting of the code with a view possibly to implement it in its own system. And the working group agreed that this would be desirable for the two secretariats to work together on this project, which has since then become a joint enterprise of the two secretariats. So where are we now with the code of conduct? Basically, there are three steps. The first one is the one I just mentioned, which is the preparation of drafts and the consideration of these drafts by the working group. And over the last 2 years, there have been no less than 4 successive versions that have been considered by the working group between its 41st and 45th sessions, with the two secretariats each time revising the provisions in the code based on the deliberations at the previous sessions. As you are aware, some provisions were agreed quite early by the working group, which is the case, for instance, for Article 3 on independence and impartiality, while other articles required more time and compromise. Article 8, for instance, on the confidentiality obligations, but also Article 11 on disclosure, and of course, Article 4 on the regulation of double hatting, which required more time and consideration by the working group. So the working group also decided at its 43rd session last year to work on the basis of 2 separate texts, a code of conduct for arbitrators and a code of conduct for judges, each to be accompanied by a commentary, and requested the secretariats to prepare those texts. The second step then in this process is the one towards which we are now moving, which is the presentation of the 2 codes to the Commission in July this year. So this means that the working group has now completed its work on the codes, and it is now expected that the Commission finalizes the 2 texts with the commentary and adopt them at the end of its deliberations this summer. There are 2 texts, but as I mentioned, the finalization of the code for judges is highly linked to the consideration on the issue of a standing mechanism reform element, which is still in ongoing discussions in the working group, and therefore the Commission would only adopt this text in principle, meaning that further adjustments to this text would still be possible pending progress made on this standing mechanism. So once these 2 texts are adopted, they will also be submitted to the General Assembly to take note of these 2 instruments. The third and last step is the promotion and the implementation of the code. This is an important issue that will also be discussed at the Commission this summer. And as the codes of conduct are expected to be a component of a package of procedural reforms on ISDS to be eventually adopted, the question of their implementation through a multilateral instrument on the ISDS reform, and eventually the relationship with existing investment treaties will also be something to consider at that point. So this was for the background aspects of the code of conduct. Now let's focus a little bit on the content of the code for arbitrators. As you can see, there are 12 articles in total dealing with the definitions, the application of the code, independence and impartiality, regulation of double hatting, duty of diligence, and the integrity and competence of arbitrators, ex parte communication, confidentiality obligations, fees and expenses, provisions on assistance, disclosure obligations, and also compliance with the code of conduct. The code also contains 2 annexes that provide a disclosure and declaration form for arbitrators and candidates. So let's focus now on the 3 articles dealing directly with the issue of conflicts of interest, which is a major topic today. And this is to start Article 3, which provides in its first paragraph that arbitrators should be independent and impartial. So this is the main principle. And then you have a second paragraph, which is a list, or a non-exhaustive list, I should say, of examples where an arbitrator could be found to lack independence or impartiality. So namely, paragraph 2 provides that an arbitrator shall not be influenced by loyalty to any disputing party or any other person or entity, take instruction from any organization, government, or individual regarding any matter addressed in the IED proceeding, be influenced by any past, present, or prospective financial, business, professional, or personal relationship, use the position to advance any financial or personal interest, assume any function or accept benefits that would interfere with the performance of the duties of arbitrator, and also take any action that creates the appearance of a lack of independence or impartiality. So as I said, this is not an exhaustive list, and there might be other examples or situations where an arbitrator could be found to lack independence and impartiality, and other texts such as the IBA guidelines on conflicts of interest in international arbitration, for instance, could also provide some relevant examples where such conflict could exist. Then, of course, we have Article 4. It contains the obligations limiting an arbitrator from undertaking other roles as a legal counsel or expert witness in other proceedings while functioning as an arbitrator. This provision has been the subject, I'm sure you're all aware, of very long and intense deliberations within the working group, and it is the result of a compromise that has been reached at the last session in March this year. So
Corentin, sorry to interrupt. I've just got a question from Nepal, which is quite useful at this point, which is from Kathmandu. Would you please differentiate between your nomination of double hatting and multiple hatting?
Well, we mentioned multiple roles, which is a more legal term than double hatting, which is more like the expression that is often referred to in international arbitration, also to encompass not just the role as a counsel that an arbitrator could undertake while functioning as an arbitrator, but also as an expert witness in other proceedings. So hence the determination multiple instead of double hatting, which could be deemed a bit more limited in this aspect.
Lovely, thank you so much.
So we have 3 main elements in Article 4, which is first a ban on which is a ban on concurrent roles as a legal representative or expert witness if the other proceeding involves the same measure, the same disputing party, or the same provision of the same instrument of consent. And we then have cooling off period where the ban in paragraph 1 applies, and this cooling off period depends on the specific circumstances that I just enumerated, which is the same disputing parties, measures, or the same provisions of the same instrument of consent. So you have 3 years if the other proceeding in which you're acting involves the same measures, 3 years of cooling off period if it involves the same disputing parties, and 1 year if it involves the same provisions of the same treaty. And it is also important to note that this cooling off period, contrary to paragraph 1, applies only to international investment disputes. So not just other proceedings, but international investment disputes. And we then have another principle in this article, which is party autonomy. So throughout the article, you have language which is repeated, according to which the disputing parties, provided that they both agree, can decide to waive the prohibitions in Article 4 or vary the effects of the obligations in Article 4, so depending on their level of concern. So for instance, they could decide to waive the prohibition in Article 4 entirely, or reduce the cooling off period, or conversely extend the cooling off period if they have any doubts in that regard. Also important to note is that Article 4 does not limit an arbitrator for performing other adjudicatory functions, such as functioning as an arbitrator in another proceeding. However, if an arbitrator engages in another role that is not prohibited by Article 4, he or she still needs to ensure that this other role does not violate his or her obligations under the code, and in particular, the obligations of independence and impartiality in Article 3. Finally, we have Article 11, which contains the disclosure requirements for arbitrators and candidates. So I'm not going to read out the article because it is quite long, but we could just note that paragraph 1 sets the general standard for disclosure, which is that an arbitrator or a candidate needs to disclose any circumstances that are likely to give rise to justifiable doubts as to his or her independence or impartiality. And we then have a mandatory list of matters to be disclosed under paragraph 2, which is not exhaustive, since certain disclosures may still be required if they would fall under the standard of disclosure in paragraph 1. So this list in paragraph 2 is mainly aimed at disclosing any relationship or interest with regard to the proceeding in which the arbitrator is acting, and also contains some temporal limitations where relevant. So for example, you have subparagraph D and also subparagraph C and D, where disclosure is required for any information regarding the proceedings in which a candidate or an arbitrator has been appointed as an arbitrator, legal representative, or expert witness by one of the disputing parties. And this is over the past 5 years. So sometimes in paragraph 2, the disclosure obligations can be limited in time, which it is not under paragraph 1. Also important to note in this list is paragraph 2E, whose inclusion is the result of the compromise reached more broadly on Article 4, and which requires to disclose to the parties any prospective appointment as a legal representative or expert witness in another proceeding, while the arbitrator would still be acting as an arbitrator in the current proceeding. And then the other paragraphs in Article 11 deal with the continuing obligation of disclosure as soon as any new relevant circumstances or information arise. You also have an obligation to make all reasonable efforts to become aware of such circumstances and information, an obligation to err in favor of disclosure in case of doubts, an obligation on the form and timing of the disclosure, and also paragraph 7, which provides that a mere failure to disclose does not, of course, mean that an arbitrator lacks independence or impartiality, but it is whether the content of this omitted information, once it has been identified, that would inform whether it is grave enough to give rise to justifiable doubts in that regard. I have been asked to speak for 10 minutes, so maybe I will stop here. But if you're eager to learn more about the content of the commentary, please do not hesitate. I'm happy to answer your questions. Thank you very much. Back to you.
Thank you very much, Corentin. And I do have one question from Rishika Jain, and just to the audience, we will take audience questions towards the end of the session, but you know, these questions are relevant. So would these regulations, Rishika says, would these regulations relating to double hatting also be applicable to emergency arbitrators?
Yes, so the obligations in Article 4 are meant to apply to arbitrators regardless of regardless of whether it is an ad hoc arbitration, an institutional based arbitration, and also emergency arbitration should be covered by this code as long as, of course, it relates to an ID, so to an international investment dispute.
Excellent. Thank you very much for that answer. Now we'll move along to really the first sort of deep topic, which is really multiple hatting and cooling off. So what are the perceived issues, and from what perspectives are the perceived issues? And for that, Loukas is going to field some responses to that.
Thank you very much, Andrew, and many thanks to Corentin for a very good overview. I will address the question without slides because I think the rest of the session is primarily a discussion. I will give you I will address the topic from two perspectives. One is the perspective of the academic researcher, if you wish, and one from the perspective of the arbitration practitioner. Starting from the first perspective, the academic perspective, I've been writing quite a bit and researching in the last sort of 6 or 7 years about the evolution of arbitration as a profession. And one of the things that has emerged through the research is that arbitration has developed significantly, and perhaps it's not a problem about saying something like that in public. I mean, if you look at the very big arbitrator names of the 20th century, whether that is Pierre Lally, for example, or equivalents, that most of them would have had 20, 30, 40 cases in their career. If you look at modern arbitrators, especially those who are described falsely as independent arbitrators, I think the correct term would be full-time arbitrators. Some of them already in their 50s or 60s might be featuring in 200 or 300 cases. So arbitration has significantly increased, and the involvement of arbitrators is much broader than it has been in the past. So a big arbitrator of the 20th century had 50, 60 cases. A big arbitrator of the 21st century might have hundreds, and some of them would even go to much larger numbers. That's particularly exemplified in investment disputes, in ISDS disputes where there's more public data. And you would see that we have people who we know that have been involved in 100 cases or 80 cases or 70 cases. Of course, that brings about an issue of whether a full-time arbitrator, so-called independent arbitrator, but of course dependent on income from arbitration, should be regulated or not. And as much as people are critical about increased regulation of arbitration and polynomy, it's inevitable. If you have somebody whose primary role is to make money out of arbitrating disputes, one would like to see quite a number of hallmarks of regulation. And if one doesn't want to do that, I mean, would appoint arbitrators who have, for lack of a better word, multiple hats. You could appoint a law professor who does some arbitration cases, or a judge who, by permission of the local authorities, judicial authorities, can sit in some arbitrations, or a retired judge. So if we move, or the direction of travel is towards full-time arbitrators, then all of that element of regulation is quite significant. And that's sort of the, if you wish, the academic perspective. Now, the practitioner perspective, however, is that any regulation and any sort of element of sort of bring about some sort of a better understanding and a better context in which regulations and independence and impartiality ultimately will be assessed is not without problems. I have to say today, for example, I was spent about an hour with a co-arbitrator trying to find a chair arbitration in a quasi-investment dispute, and I will come back to the term the quasi-investment dispute. The dispute involves, as a respondent, a state-owned enterprise. And we had a short list by sort of who we think would be suitable for the case, taking account of the diversity, have a good number of younger arbitrators, a good number of arbitrators who are female, arbitrators who are from outside the court jurisdictions. And then if you look and try to look at sort of their profile, either they have no profile whatsoever, or the profile is so sort of full that you have to make decisions. So for me, my concern about diversity is an impediment to broadening the pool of so a regulation about multiple hatting or double hatting is an impediment to increasing diversity and increasing the pool of arbitrators. And this is why sometimes if you have a case which relates, let's say, in relation to Nepal, there are very few lawyers who might have knowledge of the system similar to Nepal. And those who have and who are not Nepalese, if they have acted in one case, they cannot act to another case for a period of time. And given that cases go for a couple of years, sometimes 3 years, plus 3 years, the cooling off period, these people are disqualified for an area where they should have been appointed purely on the basis of expertise. Now, where we are, I commend, of course, Ancestral and ICSID for having sort of persevered and developed sort of a very substantial draft. And of course, they will not be surprised if they hear from me, as from others, that no draft is perfect. So as you know, the enemy of we can always do better, but of course, sometimes what is good or very good is perhaps good enough or should be good enough. What are my concerns here? Looking at the particular provision in Article 4, the 2 ports of call that I would like to make is one is the cooling off period. Of course, I would like to comment the point that with party approval, a lot of things have changed. So there's an element of party autonomy, an element of opting out, which is quite significant. And the second thing is the problem with all texts that have been produced by any organization, and that is the question of definition. So I made the point of quasi, in short, for the broader audience who might not be so well versed, Article 4 says that somebody who has acted as an arbitrator in a case cannot act in any related capacity of arbitrator, expert, or legal representative, or for a matter relating to the same parties, the same issue, same legal issue, for a period of time. And that is set up at 3 years. Whether that's short or not short, that's a matter of debate, but that's not perhaps an issue of real debate. The question is that somebody, because of acquired some expertise, they can no longer use the expertise for some time. Now, Corentin made, of course, the point that is the reference to the text that this relates to IIDs, international investment disputes. And the question is, what is the definition of international investment disputes? So as part of this exercise that I was referring to earlier with my co-arbitrator in appointing a chair, we looked at a number of directors. We didn't have both of us access to Jus Mundi conflicts checks, unfortunately, but we looked at the investment reputation reporter, we looked at the GAR art database. And of course, if you look at the investment reputation reporter, which is supposed to be about investment, and pick up somebody, you see in these cases, none of these cases is an ICSID case about a particular individual, but involves a state or a state agency. It's unclear from that summary of the case whether this is based on an international investment agreement or not. But of course, if it is listed there, you could argue that that must be an investment dispute. Although it might not be an investment dispute because it might be a construction of a highway in an Eastern European country, or it could be sort of a project sharing agreement, production sharing agreement in an oil context, or a licensing agreement. So that definition is going to be a matter that would be perhaps an issue of contention going forward. And I'm not sure that there's perfect solutions. Perhaps a solution could come, and I know that Corentin and Jay had not had the chance to talk about it, but of course the commentary, and once there's, of course, there's practice, that would inform further matters. The couple of things that I wanted to add here is that, so not allowing a 40-year-old for some time to act in a matter because he has acted as an arbitrator, that for me is a bit of problematic. And it seems that we are ignoring the past. I mean, we want to have a sort of a disclosure code of conduct system with a clean slate. While we look back and look, some of the drafters or people who are involved in the drafting have been people who have multitasked, multi-hatted, or double-hatted, and then of course that clean slate means that there's a generation of people who perhaps in their 40s or 50s certainly that would be squashed because they will not be able to act and develop that level of expertise. That to me, from an academic perspective, seems to be unsatisfactory. From a broader perspective, of course, opening up the pool is fine. And the final comment I want to make, because we all have sort of certain time limits in how much we address, I wouldn't have the same hesitation if that matter was relating entirely to judges in a permanent body. I think arbitration has a slightly different dynamic and is more party-driven than a permanent sort of body, a permanent investment court. And I think that I would like to have seen a bigger, even a broader sort of difference between the two models. I think we are going to be debating this matter for some time, and I see that a lot of the double-hatting exercise came out of the issue conflict. And as an academic, it would be interesting to see that the ICA task force that looked at issue conflict really came with non-sort of clear conclusions. So sort of described the phenomenon, but left it sort of without a particular sort of black letter suggestion, because actually there isn't. Even cases involving the same parties, if one looks, for example, at the Spanish renewable cases, in every single case, which is prima facie similar, there are a lot of nuances, not least accentuated by or amplified by advocacy, but simply the way parties put the case forward. And not all measures impact on the same way on the same parties. So absent any sort of parallel proceedings, we've seen that in Argentina or in Spain, tribunals have gone different ways. And I think we are perhaps going to see that a bit more rather than less because of the double-hatting sort of provision we have seen. And I would rather stop here, and then of course I'm happy to address any further questions.
Well, thank you very much. And just to our colleagues, maybe a few minutes if you wanted to reflect on anything that Loukas just said, you're welcome to for the next couple of minutes, and then we'll move on to Karina.
Perhaps one comment, Andrew, but I think Jay and Corentin may want to add. As you know, the Article 4 was very much debated and swung between total ban to what we have today. One thing I wanted to add when it comes to double hatting is if we go back to the initial concerns or initial discussions about the concerns raised in the working group 3, the emphasis was placed on the legitimacy of ISDS, and the legitimacy of ISDS meant that states in the working group 3 have emphasized that perception is a very important element in this exercise of legitimacy. And the double hatting at the time when it was discussed, I believe it was the 35th session of the working group 3, double hatting in particular was put at the forefront of having that negative impact on the perception of legitimacy of ISDS, and not necessarily what Loukas was saying when it comes to the work of ICA on issue conflicts. It is not the actual conflict. It is not the actual conflicts that stem out of this multiple role, but it is the perception, the negative impact on the perception of legitimacy of ISDS. And I think this is where, when drafting Article 4 and also in the informal sessions and formal sessions of the Working Group 3, there was this great, I would say, emphasis on making sure that what transpires ensures this legitimacy. And the other thing that was also mentioned during the discussion was the parallel with the IBA guidelines, the fact that the matter is not addressed in the IBA guidelines, and to what extent this should be reflected in the code of conduct. But as Loukas was saying, and as Corentin was presenting, it is an intertwined aspect with ramifications. Also in the IBA guidelines, you can find traces of where double heading will hit on the duty of disclosure and independence and impartiality of arbitrators. And the same goes for the code of conduct. Thank you, Andrew.
If I may have one comment to make, and perhaps also a question rather than a comment. I understand that the broader concern is legitimacy of ISDS, and everyone who is involved in investment arbitration and commercial arbitration, of course, would like to ensure that the process is very well received by users ultimately. And I'm quite surprised that the view that has been taken, and I think Corentin make the point, is that an innocent non-disclosure would not be detrimental as such. And I'm thinking, without naming ad hoc committees, I wonder whether that is an appropriate way forward, sort of the innocent non-disclosure not to be an issue. Shouldn't there be a duty on arbitrators to investigate? And in this particular annulment committee I had in mind, I said there has not been a proper conflicts check and a proper investigation. But still, because while the case has gone and it was a unanimous decision, a majority decision doesn't affect the process. Shouldn't we expect, as part of the process of being appointed, a very thorough conflicts check? That's the question to Corentin. And I know that this is perhaps one has, I mean, mistakes can happen, there can be innocent mistakes. And I wonder, and the second point, which is perhaps goes towards Krina and where she would be going, isn't perhaps double hatting a way of filtering or reducing sort of repeat appointments, and perhaps that's sort of the very positive outcome.
So maybe I can respond Loukas' question, and maybe Jay can complement if he wants. The working group added this provision on the fact that the very fact of non-disclosure does not mean, of course, that you lack independence or impartiality as a kind of safeguard. But of course, the signal is not to encourage arbitrators or candidates not to disclose on such information. This is really an attempt to prevent also potential frivolous abuses of this obligation of disclosure, and to show that as long as an arbitrator has put everything, all reasonable efforts, which is also in the article, as long as he or she has put all these efforts in finding the information, then the very fact of non-disclosing should not be as such a signal that there has been a breach of Article 3, but really it's the content of this information which eventually will lead to an assessment of whether there is justify or adopt as to this lack of independence or impartiality. So this is really not an encouragement, of course, not to conduct a proper assessment of conflicts of conflict checks from the part of arbitrators. And nowadays there are also very thorough tools in order to assess this conflict checks. So I think all this considered arbitrators are really prompted in disclosing as much as possible.
Excellent. Thank you very much for that response. Jay, did you have a quick response at all?
Well, actually, I wanted to go back to the double heading issue because I think we have to understand that we didn't start the process in order to regulate the conduct of full-time arbitrators. That was not the purposes of the working group. It was to actually pinpoint to the concerns that were raised, and the three options that we had was to the INI, the independence and impartiality provisions, and the disclosure provisions. But then the most problematic ones, and that is why I am saying that these the double heading provisions in the code is a very qualified regulations, because they only relate to proceedings involving the same parties, the same provisions, or so it is qualified, and therefore we're not trying to regulate that conduct of full-time arbitrators. And that's one point. Second point was that one of the objectives of double heading is to increase the diversity. Contrary to what Loukas has said, some were saying that the ISDS market is being too packed with few ISDS arbitrators who actually jump back and forth between becoming a legal representative and an arbitrator, and therefore double heading could actually contribute to increasing the diversity. Was one of the reasons that were put forward for regulating the conduct of double heading. Just one last point. In the last minutes of the discussions, I think the parties, the states that were in the room that were negotiating the code of conduct were very keen on ensuring that they had the right to choose the legal representatives and the arbitrators that they need for their party appointments. And that was one of the concerns that actually led to the cooling off period being 1 years. And that was kind of the balancing the right of the parties to appoint the legal representatives and the arbitrators that they want, and then addressing the concerns that arise from these arbitrators functioning as a legal representative within the 3 years after the proceedings. So I think I just wanted to point out those 3 points before we move on to the discussions.
Oh, very good. Thank you very much. And we will move on now to Corentin with the complementary, really a complementary topic, which is really party autonomy. So really, what is party autonomy balanced with in the new code? And Corentin is going to address that, and we're going to have some discussion about that.
Thank you, Andrew. And Corentin has mentioned already that we have expressly party autonomy in the code of conduct for the cooling off periods, which can be altered one way or the other under Article 4 on the multiple roles. My focus is, as you said, is to what extent the code of conduct limits the party autonomy. And although we admittedly there is no such fundamental right of appointing an arbitrator in international arbitration, it is considered to be one of the features, positive features of international arbitration, and in particular in ISDS. Loukas was referring to the repeat appointments, which if we look at Article 11 in the final form of the Code of Conduct, we see in paragraph 2 at letter D that we have the arbitrators will have the obligation to disclose any appointment as an arbitrator in proceedings in the past 5 years. And of course, the repeat appointments is very much related to issue conflict, or if we want to rephrase that as prejudgment of issues in investment cases. And one can conclude that it is, or at least as it was coined at the beginning of the discussions in the working group 3, repeat appointments have become one of the issues as such presented, limiting the pool of arbitrators and raising concerns as to the independence and impartiality. Now, it is very interesting because repeat appointments, one would tend to think, well, this is also regulated in the IDA guidelines. It should not be an issue of concern. But the repeat appointments that are probably of most concern in ISDS are the repeat appointments by the same side, and not necessarily the same party in the sense that identity of the party or same type of party, I would say. So the investor exclusive appointments by investors in the state in the ISDS proceedings, or exclusive appointments by states, and therefore the perceived bias of favoring a certain position in ISDS proceedings. But of course, this is something that was extensively discussed, and several concerns have been raised. One, of course, impacting the pool of arbitrators, creating a somehow dependence or financial dependence by the party appointing the arbitrator. And as I mentioned earlier, even developing this affinity towards a certain side of arguments, either pro-investor or pro-state. And at the beginning of the discussions in the working group 3, I remember ICSID has emphasized that in the challenges to arbitrators under the ICSID convention, based on repeat appointments, there has been no successful case relying exclusively on the ground that repeat appointments would generate that actual conflict. And we had several cases in which this was raised. 2 years ago, very interesting case against Spain, which I think it came after the ICSID and the UNCITRAL drafted the initial papers informing the states on the background of these issues. The chair of the ICSID Administrative Council had to decide on a challenge to an arbitrator based on repeat appointments, and I mentioned it was Spain. Loukas has mentioned the numerous cases against Spain, and if you look at the arbitrators appointed in this case, it's a very small pool of arbitrators, kind of dancing chairs. The element which was in addition to the repeat appointments was the fact that the arbitrator had issued dissenting opinions in 2 other cases against Spain. What I found interesting in this case is the position that Spain, as the challenging party, put in this arbitration, and has stated that the multiple appointments of an arbitrator by a party or its counsel is not in itself a reason to challenge, but constitute a consideration that must be carefully considered. And this circles back to my comment earlier on multiple roles, which is an issue of perception. That Spain also said that multiple appointments are an objective indication of the view of the parties and their counsel that the outcome of the dispute is more likely to be successful. And I think this comments goes to the fact and also related to the prejudgment of issues, to the issue conflict. This repeat appointments would give the comfort to the party or the side appointing the arbitrator that in one way or the other, the outcome of the arbitration will be in a certain way. Now, I mentioned this case had 2 is the VM Solar versus Spain. The case, the arbitrator had 2 dissenting opinions, and I think this is where the peculiarity, because of course dissenting opinions they are personal and they can reveal more than an arbitral award can reveal. Now, irrespective of this, the chair of the ICSID Administrative Council rejected the challenge, saying that multiple appointments are not per se sufficient to justify the removal of an arbitrator. And the emphasis was put on the threshold for establishing the lack of independence and impartiality. That objective approach, and of course in the context of ICSID, even more particularized to the manifest lack of independence and impartiality. I do believe that when it comes to the code of conduct, this was very much taken into consideration, and in the discussions, of course, this transpired. Now, Article 11 on the disclosures, I think it's important to note that it refers to appointment in other cases, and this is also mentioned in the comments and was discussed. It is the appointment that has to be in the past 5 years. But it may be that the disclosure has to be done, as Corentin was saying, irrespective of this period of 5 years under other headings of Article 11. An arbitrator has to err in favor of disclosure. So we'll probably see, I would say, an extensive disclosure rather than a limited one. I'm of the view that arbitrators will be careful, especially because ISDS, most of the proceedings are transparent. But at the same time, it's very difficult to determine the impact of repeat appointments on the independence or on the bias of the arbitrator. The prejudgment of issues, it is a serious concern. What is not in the code specifically, but is in the comments to the code, and this was a compromise. When it comes to, I was mentioning in favor of disclosure, the question whether arbitrators have to disclose their publications, their speeches, or any similar. And in the comments to the code, you are going to find that arbitrators should do that, which for an academic obviously raises very, very important questions. I had this discussion recently about how much can you say when you publish. You have to be careful not to find among those presented something that will raise the questions to the bias. Academics, and Loukas can confirm this, you have to be critical to be published. If you're descriptive, there is almost zero chance to get a publication in a journal. So I'm still concerned. I know that many have raised this issue. It is in the comments. There is a broad obligation to disclose. All in all, meaning that there is certain limitation on party autonomy when it comes to the choice of arbitrators. But again, the outcome of the code is the result of addressing the perception or the negative perception as to the legitimacy of ISDS. I think we still have to see in the application of the code if there is a real impact on, for example, expanding the pool of arbitrators by having these limitations on the repeat appointments. Thank you, Andrew.
Oh, thank you very much. And just quickly throwing to our colleagues for perhaps comment on that and give the audience a bit of an idea about where we're headed. So we'll throw to some comments here, and then we'll do maybe some comments on client perspective and really bringing all of this together as a group, and then we might have time to address some online questions at the end. Loukas.
I have a short comment. I think there seems to, I mean, I have difficulties to fully classify the cases where, on the basis of repeat appointments, there has been a removal or disqualification. For example, we have Burlington in Ecuador, where Francesco Vicuña was disqualified because he's been appointed repeatedly, 7 or 8 cases by the law firm. We have the disqualification of Bruno Boss in Karachub and Kazakhstan. So we have cases where the repeat appointment has been an issue of challenge, and cases which are completely oblivious. And I very much remember the earlier parts of discussion in the Arsenal Working Group, where one European Union state had said that for them, it is a matter of party autonomy to appoint the arbitrator in whom they have the most trust. And trust might be that sometimes they have seen them, not necessarily that they have a relationship. So the perception is that one should be perhaps stricter in repeat appointments. That certainly will fit into the question of expanding the pool and diversity. If one were to go as far as to say that there should, and that's perhaps a a matter for institutions rather than a code of conduct, so that they would refuse to confirm arbitrators who have been appointed in or currently acting in more than a number of cases. But this is a concerted effort, and of course, the right to appoint an arbitrator might not be a sort of a constitutional right, but in the arbitral ecosystem, it seems to be one of the driving forces of arbitration, that you can choose or somebody would assist, and that process would assist in legitimacy and the trust in the process as well.
Excellent. Do you have any responses to that, Jay or Corentin or Krina?
From my side, I think, as Loukas kind of hinted, repeat appointments are done by parties. So it is actually the conduct of the parties which cannot be regulated by a code of conduct on arbitrators. And I think that's why the approach taken by the working group in preparing the draft code of conduct was through disclosure requirements. By disclosure in 11.2d, the other parties are aware of these appointments. And as Krina has mentioned, even if it's not within the 5 years, if they raise justifiable doubts under 11.1, you are supposed to disclose under that one. So I think that is the approach taken by the working group. And of course, as we were discussing, if once you disclose the information, the parties have the right to challenge the arbitrator, which is the next step in actually addressing repeat appointments and any issue conflicts arise. So although the code does not address repeat appointments and issue conflicts directly in the article itself, as Krina and Loukas has mentioned, the commentary tries to address how they are to be addressed in the bigger context of the bigger picture of the code.
Excellent. Krina, did you have something to say?
Yes, if I may add, especially because there was, I think there's a question in the chat about the confidentiality obligations, and this was also, of course, addressed in the working group 3, that the full disclosure may affect the confidentiality obligations of the arbitrator, what we have now is the outcome, obviously, of the discussions. It has to be disclosed, bearing in mind also the relevance of confidentiality. Another point which was made in the working group 3, one discussion about the full disclosure, and I include here publications, is that it also serves to demonstrate the qualifications and experience of arbitrators. So it is not, as Jay was saying, this is not an exercise of catching the arbitrators and how they're doing, but it's also to demonstrate to all the parties involved that arbitrator is competent. I remember one comment, now I don't remember if, I believe it was United States at the beginning of the discussion, which one has to think about the full disclosure that it shows an approach of the arbitrator to a particular argument or to a particular position, but at the same time, this should not be considered that any disclosure will be, as Jay was saying, will be sanctioned with a challenge. So from this point of view, I think there are many facets of the duty of disclosure when it comes to what the arbitrator should consider to disclose or not. I think it's important to have in mind the independence and impartiality, Article 11, the first paragraph.
Oh, perfect. What we might do is we might move on to perhaps, I think Loukas and Jay have some comments on the client perspective about this, particularly there was a Queen Mary University of London survey in 2020, I think, that was raising some interesting issues. We might take a couple of minutes on that and then turn to just bringing it all together.
Thank you. I mean, I think it's a common expression that it takes two to tango. So we don't have a dispute with one party. There's always two parties to the dispute. And Queen Mary has done a survey in late 2019 and early 2020 in conjunction with the Corporate Council International Arbitration Group. and the view was the objective was to canvass the views of corporate users of investment arbitration, and also to present to corporate users some of the themes of the ISDS reform in Working Group 3 and gather the reactions. Perhaps the two main takeaways that I would like to present very briefly is, one is that overall, it seems that the direction of travel is that the larger corporations very much would opt for contract-based arbitration rather than ISDS, or in other words, sort of investment treaty-based arbitration. This is because they can they have more flexibility about how the process will be organized. Secondly, they have a higher level of confidentiality in the process. So there's much more limited transparency. And therefore, they think that this is a process that seems to be working for them better. The second main takeaway is that the reaction towards the reforms was very pragmatic. The things they like, the things they did not like, that's sort of everything's a matter of taste ultimately. But one of the striking responses was that they would be engaging with the process, whatever the process is going to be, as it best fits their needs. So it's a very pragmatic response. The things, for example, they did not like and is relevant to our topic is if there was to be a significant limitation of the access to the arbitrators. If, for example, one of the things they did not particularly like was an investment court system where you have a very small pool of arbitrators. If you have a broader pool of arbitrators, for example, something akin to the exit list, that it doesn't seem to be a problem, even if it is in the context of a permanent body. So a rather pragmatic approach, and of course, one of the limitations of the survey was that we did not canvass as much the views of small and medium-sized enterprises, for the very simple reason that a lot of these companies do not have a permanent legal team, and they rely very much to outside counsel. There's no institutional sort of memory or access to the data. And some of the small and medium enterprises appear to be the bulk of the users of investment arbitration at the moment. If you look at the exit list, there are very few multinationals. There are a few, perhaps half a dozen, but there are not dozens of multinationals if you look at who the claimants are.
Excellent, and I'll put that link to that research in the chat box. Just sort of as concluding comments, what we might do is we might address the issue of perhaps how we should look at the code, perhaps looking mainly to the past and see where the code is up to, rather than necessarily looking to the future on that and see how that process went. We might do a couple of minutes on that, and then I might just extend this seminar for maybe another 5 or 6 minutes, and we'll just address some final questions that maybe the audience has. So we'll do another 6 minutes from here, but very quickly. So I think, Karina, you had a mention of a paper on independence and impartiality of arbitrators that was released in 2018, and I'll look for the link for that and post that in the chat. Did you have some comments on that process from then until the present moment?
I think it's a valid question. I wanted before that perhaps briefly refer to Article 2 of the Code of Conduct, which concerns the application of the code. And this was one of the questions raised early. What happens if the Code of Conduct will come in interaction with other codes of conduct? For example, for the instrument of consent. For example, CETA, which has a code of conduct for the arbitrators, then you also have the UNCITRAL code of conduct, and this is addressed in Article 2 of the code, which says that the present code shall complement the existing provisions in the instrument of consent. So arbitrators have to be mindful to observe and address both code of conducts when they would coexist. And if there is an incompatibility between the UNCITRAL code of conduct and the one in the instrument of consent, the one in the instrument of consent shall prevail. So I think when it comes to the future and I would say the application of the code of conduct, the UNCITRAL code of conduct, it will be interesting to see in practice how this is going to effectively work. But I guess we have to wait and see. When it comes to the initial steps in putting together the code of conduct, and Jay and Corentin, of course, they have more insight into this. What was presented to the working group free as to the concerns with arbitrators was the concerns on independence and impartiality. And as you mentioned, Andrew, there was one of the papers prepared by the Secretariat concerning this particular aspect. There have been several points raised in the question in the paper, including double hatting, repeat appointments, issue conflict. What was raised and I think this have been addressed obviously by the code of conduct. I think what was mentioned in the paper was the challenge mechanism, and this is something that was very much discussed. So in terms of achieving the objectives as set out in the beginning, or at least emphasize the issues emphasized in the beginning, I believe that the code is addressing most of them. But perhaps Jay or Corentin, they might want to add specifically on the paper.
If I may, not specifically on the paper, but I think as Corentin mentioned in his original introductory remarks, we do have to discuss the implementations. It's a soft law text. It has not been referred to in any of the investment treaties yet. So in order for it to apply, there has to be some sort of a reference. So we will be looking into that implementation issue, including in relations to possible challenges based on the code. And I think this is what the Commission will discuss in July when we discuss and finalize the code. Going back to the client perspectives, as just one misperception that people have is because UNCITRAL is an intergovernmental body and state representatives participate, some people see it as only representing the views of the states. But as Loukas and Krina here knows, we also have NGOs being represented in the working group, and the states themselves also consult with the investors and the corporate users on how they state their positions in the working group. So it is not only governments that are represented in the formulation of the code, and we think that it is the interest of all the investors and the respondent states all being represented in the process of compromises being built by the working group. Of course, we have to do a little bit more. It is difficult to actually get the voices of the investors and the corporate legal representatives all in the same place and to have the same voice for it. And that is why the working group and the Secretariat is reaching out to a number of the investor NGOs to get their perspectives on board as we make progress and as we prepare the drafts. So that's how the progress has been made. And I guess, so we currently think that the code does reflect the perspectives of not only the states, but clients as in investors as well.
Just to add that, maybe
go ahead.
We also reach out to the broader community, to the broader arbitration community, also to collect comments on the drafts that we published on the website, and these comments are also taken into consideration when we revise and when we try to really address the issue in the most comprehensive way. And yeah, we received comments also from practitioners, and these have been very helpful as well for us to have this broader picture and to also see what were like some of the issues that may fall into the cracks, or things that the commentary could address also, possibly by putting some illustrative examples, or trying to really cover the scope, the entire scope of the articles. So yes, that's also very useful for the work of the Secretariat.
No, terrific. Well, thank you so much, all of you. One thing I wanted to quickly do in this last remaining minute or two is really just to get to some questions that our friends and colleagues have asked here. And I've got one regarding multiple hatting being used as an incentive in arbitration, and arbitrators are accustomed to that system. So if it is to be restricted, what would compensate for the lost opportunity? And does anyone have a 1-minute answer on that? Nope, we don't. Corinna, maybe.
Well, I was Loukas. I think he mentioned exactly what are the drawbacks of prohibiting. I think the major concern expressed in the discussions was exactly this lack of experience for arbitrators. It is very difficult to, in particular in such complex cases, it is very difficult to have experienced arbitrators without seeing them or without seeing these cases closely from inside, as in particular as counsel, for example. It is very difficult to come up with a solution, and probably the industry will going to have to self-regulate to some extent. One proposal was to have this, if I remember from the discussion, to have this shadow arbitrator sitting in the proceedings. So you have to learn by looking at it, but obviously it's not the same.
No, excellent. Any other comments before we close up the discussion? Any comments from our panelists at all? Excellent. Well, thank you so much, and thank you for the audience sticking with us. And thank you from Jus Mundi. Our perspective is that it is a huge privilege to have such great expertise. So we had today we had Jus Mundi, Corentin Baslé, Dr. Corinna Boltag, and Professor Loukas Mistelis. And it has been fantastic discussing this important topic. And if anybody has any queries or questions, please reach out to Jus Mundi on the chat. You'll see on jusmundi.com there's a chat provision chat button if you have questions, and that will filter through the system back to me, which is terrific. Thank you all again. I will now end the proceedings, and thank you again for a great dialogue. Have a lovely afternoon or morning, depending on where you are.
Thank you very much.
Thank you, everybody.
Thank you.